Welcome to the fourth episode of Droit, our weekly Tuesday show exploring the legal side of the FIFA World Cup. This episode is brought to you by Hutteau-Hiltzer Law and by the Sports Law Commission of the European Lawyers Union. Today's episode is a very special one. It will be conducted entirely in English, as one of our dear guests is not a French speaker. But don't worry, to our French audience, you will still be able to follow along. There should be some French subtitles on that video. So today I'm delighted to welcome Agustín Bonaveri, who is a professor of constitutional law in Buenos Aires, and he also serves as clerk of the court of the Judicial Council of the city of Buenos Aires. And I'm also delighted to welcome Pol Minguet, an attorney licensed to practice law in New York and in California. He also serves as a lecturer at UC Berkeley School of Law. Hi, Paul. Hi, Agustín. I'm very happy to have you.
Well, thank you for having us, Anso.
Thank you. Thank you very much for the invitation, Anne-Sophie.
So I'm convinced that thanks to you, today's discussion will be super insightful. So let's talk about how Argentina blocks parents behind on child support from the 2026 World Cup. A few days before the start of the World Cup, the Argentinian government announced that it had submitted lists of its national subject to stadium exclusion for non-compliance with court-ordered child support obligation. So we need to highlight something interesting, first of all. This measure constitutes only a restriction on access to soccer stadium rather than a restriction on international travel. That means Argentinian national included on that list are prohibited from attending matches, are being barred from purchasing tickets and entering stadiums, but are not subject to any travel ban. That means they can enter the US, provided, of course, they comply with the immigration law, but they also can depart from Argentina. So obviously, this measure raises a number of legal questions, particularly concerning the proportionality and the legality of restricting access to sports events as a mean of enforcing child support obligation. So, Agustín, as a professor of law in Argentina, could you explain the context behind this measure and maybe from a constitutional law perspective, how it can be justified? Just can you give us a bit of a heads up, please, on that measure?
Okay, well, to begin, I would like to briefly set the stage so we can understand what is going on. So first of all, I will start with what is a child support in Argentina. And I think that it's similar in other countries, but I will tell you in Argentina, it's about food, healthcare, education, clothing, transportation, any basics day-to-day child's need to grow up healthy and happy. So the question is, what happens if a parent fails to pay this court-ordered child support? So here we have two layers. One that we can call judicial. It's a measure that state a judge. And other that is administrative. So the first one, the judicial, is case by case. The judge can decide in order to enforce this obligation. For instance, bans on leaving the country, that is very, very harsh, extremely. A driver's license suspension, or also stadium, concerts, club entry bans. And this is one of these that we are talking about in the World Cup. So this judicial layer is in each case, and it is decided by the judge because it's based on the civil code. Our civil code say that the judge can do reasonable measures to secure compliance. These reasonable measures are diversity. You can do a lot of diversity measures. So in the administrative layer, well, we have a federal system. So each province, it means each state, can have their own registry, you know. And in Buenos Aires city, the registry send the list of people that are banned. It's called Safe Stands. This Safe Stand is a program that is used originally to keep out violent people in the stadium. But now, since 2025, it includes the parent that don't give the child support. So, what happened with the World Cup? There is a resolution from the security minister that put a list at disposal to the U.S. Embassy in Buenos Aires, Argentina, with these people that are in the list, the people that didn't give the support to their child. And this was the goal of this list is to put some security standards in the United States. But that's all that the government gave to the U.S. Embassy. And this is grounded on previous bilateral agreements, because it's very important to accomplish the principle of legality. So we have some previously agreement to cooperate with United States and Argentina, and in grounded on this, Argentina gave to the U.S. Embassy the list of the people in this Safe Stands program that it's called.
So basically, you're saying that the ground to provide this list was for security reason, right? If I have understood well.
Yes. The agreement, the previous agreement is from 2016. It's about security between both countries. Okay. So in that frame is that Argentina gave the list, the information, and only for that purpose.
Okay, all right. That's interesting because maybe we will discuss that later, but of course, this measure raises, concerns about the legality from a constitutional standpoint, from a judicial standpoint, etc., but also from a data cross-border data transfer, actually. But okay, so Paul, now, as a law practitioner in the U.S., to the best of your knowledge, has this measure really been implemented? And maybe from a constitutional law perspective, is it constitutional? Would it withstand judicial scrutiny? Underlining that we are speaking about non-US citizens, by the way.
Yes. So I would say they're being implemented only in the press and not in practice. This is to say that when DHS, so the Department of Homeland Security, and the FBI, get the list, now the question, what are they doing with that? How can they, block foreign citizens to enter the US? So the easiest way, is like we have the list, people scan their passports at the airport and they get denied. And for that, DHS has a lot of power. Remember Trump travel ban around 2016, 2017?
Of course.
They have extreme power to deny people on pretty much whatever ground, and there's not many judicial review on that. Now, when we think about how we can implement that, when the list is there, how do we know that's the right individual? Many people have the same name. First, is the list current? If the person paid the child support, in the meantime, how do they know? And I think that also created a lot of difficulties. So to the best of my knowledge, and I read the press and everything, it's kind of nothing has been done to block people entering the country. No, again, the US and DHS have broad authority and power to deny people for whatever ground. And Agustín, I learned something from you today, which is very similar in America. If a parent doesn't pay child support, a state has the power to suspend the driver license, garnish wage. As an attorney, we could have a license suspended too. But it's a measure that is done about a public license. Now, where it creates additional layers of difficulties is to block people that's already on US soil. So they're being admitted, they have the visa, they're here for the World Cup. Now it's going to be very difficult for the US government to direct the stadium and the FIFA to deny entry. And this is because it's directing a private entity. And in America, generally speaking, the people do not like the government interacting or giving direction to private entity. And on that base, I think nothing has been done. It's a beautiful idea. I talked with people at the office this morning. I tried to test the water to see what is your thought on banning what we call here deadbeat dads. Mostly the dads, sadly, that do not pay child support and go enjoy, like especially pricey soccer game. I call it football. Okay, football game. Because when a ticket's around like $1,400, $2,000, and that person doesn't pay child support, it hurts. And most people around the office and I talk to, they're like, that's not a bad idea. No, I think it's very hard to implement. So it's more so an idea, but in practice, very hard to make it work. And it will not pass, the constitutional muster, I believe, if we have a law that implemented that, especially because now we are taking likely foreign judgments and want them to implement it in America without giving them the proper scrutiny, without having a stamp from a U.S. court that say, hey, that person didn't pay child support and have a U.S. court document I can enforce. The U.S. is very shy to enforce foreign judgment. I know we have agreement, we have convention, but it's all that process that need to be done before we can just implement a judgment from a foreign country. So I think that's where we stand right now.
Well, that's interesting because speaking for France, we don't have such register. To the best of my knowledge, I don't do family law, but I really don't think we have that, and I don't think there is also revocation of license, driving license, attorney's license. No. We discussed with Paul about that. The US is very transparent about, there is a transparency culture where you can basically see everything about everyone.
Yes, it's very public. So as an attorney, a good example that we talked before this meeting, I can go to the court website and I can obtain a copy of every judgment and filing. Criminal courts, civil courts. If you Google my address, you can see the transaction and things like that. And that is very American. So everything is transparent. If someone is convicted, there's a listing. You can know if your neighbor committed a felony. It's that transparent. So it's not shocking for us from an American eyes to have a list of people that do not pay child support. We're like, okay, that's part of, open courts.
Yes, no, it's totally different here. Every court order, every court decision is completely anonymized, and to have access to those anonymized court decision, you can go on a website. It's a public website, but all the court decisions are not necessarily uploaded on that. So now it's getting better because you have some private companies who have developed the access to those courts decision, but it's only, basically it's only accessible to attorneys, but it's still anonymized, because that would be considered really as invasion of privacy here. So a complete different mindset. So I don't know, but Agustín, how is it in Argentina, by the way?
Well, in Argentina, our constitution is rather similar to the United States Constitution. We took the basis of Philadelphia. So the court have drawn limits or harsher measures, to ban traveling abroad or to go to other parties. That's a limit. But I think that it's a constitutional justification to this kind of measure, because for at least 3 points. First of all, we have in our constitution the United Nations Convention on the Right of Child that has a constitutional rank similar, equal to the Constitution. It's not in the Constitution, but it's in the same level for us. Some human rights treaties, such this, have the most important level in our legal system. So, in order to the best interest of the child or the child right to life and dignity, we can go not only by the law, but also from the Constitution to enforce this kind of measure. Also, we have always to take care of proportionality and reasonableness. We have to see if the restriction is adequate to the goal, if it's the less restrictive alternative available, and finally, if it's imposed only after less invasive tools. So if you can, this constitutional test of reasonability doing well, when in that case it is possible to use this kind of tools. And finally, and very important, it's a civil reason. It's not a criminal sanction. It's a measure that is coercive in order to, well, as I say, as the civil code said, reasonable measures to secure compliance. So if we have this framework, these 3 items, in my opinion, the measure is in order to be able constitutional. So and in that case, I think that it's similar to the United States. Is that right, Paul?
Yes, I think it's very similar, because being civil, it will be the lowest amount of scrutiny that the Supreme Court will give review. It's not a very invasive mean. What would be hard here again is to direct a private entity, the FIFA of a stadium or a team, to ban people from entering a stadium. I think that's where it will face a lot of lawsuits and a lot of fight and pushback. But being civil, that's also probably why DHS didn't do anything at the border, because we all know, if you travel to America, those form, have you committed a felony when you enter in the country, and based on that, they're likely to deny your entry. But for something that is as unfortunate as not paying child support, I don't think the government will really do anything, because it's more so a civil offense than a criminal offense.
Yes. Well, that makes sense. That's a civil. That's be seen from a civil perspective, because I think it makes more sense, of course, because otherwise it would be very unbalanced. So also, I do have something in mind. So I told you that a bit earlier. To me, this measure and the way it has been done really raise question regarding the transfer of personal data, because it's a cross-border transfer. So, to the best of my knowledge, Argentina has a data protection legislation whose core principles are largely aligned with the GDPR. And I mean, correct me if I'm wrong, Agustín.
That's correct.
As a data protection law, right?
Yes.
So, like for instance, the GDPR imposes strict requirements on international transfer data. For instance, under the GDPR, and I'm thinking about the US because, you know, we had a lot of jurisprudence between the US and the EU. So, for instance, under the GDPR, in the absence of an adequacy decision, to be able to transfer data, you need to meet some requirements. And if I say it properly, under the GDPR, you have the Article 49, which puts some condition, and if we meet this condition, you can transfer those data cross-border. So, but it's very restrictive, you know. So you have some condition. One of them is that the transfer is necessary for important reasons of public interest. So if the GDPR and if the Argentinian data privacy law are quite similar, do you think this could be used? And also another condition is non-repetitive transfer involving a limited number of data subjects which are necessary for the compelling legitimate interest pursued by the controller, provided that a case-by-case assessment has been carried out and the supervisory authority and the data subject have been informed. So, you know, so this second condition, you have condition in the condition. So, I don't know if you have this measure in the Argentinian data protection law, but under the GDPR, maybe such a transfer could be legal. I don't know. I'm not very sure because, for instance, when I stated this second condition, you know, a limited number of data subjects, I think the number of Argentinian national were quite numerous, actually. It was like a lot. So is it a limited number? And Paul, you said at the beginning, what if in the meantime they paid their the child support? How it's a case-by-case assessment, like, you know. So I mean, this measure and this cross-border data transfer really raise question to me, maybe because I'm doing compliance in my practice. I don't know, but so Agustín, do you have any insight about that? Or
well, in Argentina, this registry works without taking care if the father pays or not pay, because it's automatic, it's objective. The judge is the one that works case by case and can make the difference. So this is an issue, a constitutional issue, as Paul said, that could be a problem. And about the legal data, so always we have to respect the principle of legality. That means that authorities can only act on the basis of a valid law. The valid law in this case is a resolution from the Ministry of Security that say that this list and the information can be used only for this purpose in this World Cup, and also establish that it could be, if it is necessary, for 5 days after the end of the World Cup.
Okay.
But that's all. So it is a limit to protect the.
Okay. So the legal basis for the cross-border data transfer would be this. I mean, the legislation. I mean, this measure, basically. Okay. All right. Okay. Well, I learned something about data protection in Argentina. Thank you.
Okay.
I mean, I've learned a lot from both of you, of course, but so yeah. I mean, do you want to add anything, or should we wrap up this video?
Well, my personal point of view, I think, is I'm a bit disturbed about sharing people's data like that, especially in a cross-border context, because know that the US get the data. Well, we have them. That doesn't mean we're gonna give them back. It's here. We're gonna, they're gonna do whatever they want with those data. No, I think it's good to pressure people to pay the child support and to have riches beyond just garnishing wage or suspending your license in your own country. It's good to think that we start being creative, especially when people want to go enjoy the World Cup. It's like, if you really want to go to see that match, especially because Argentina might make it to the final, well, just pay your child support and you go enjoy the match. And I think that's a good thing, to be creative and to find means to kind of make society and families better. No, the way to do it's probably not the best and not the most effective, because you cannot force a different country to implement your law and your policy. That's very hard to do. That's the bottom line, I believe.
Well, Paul, that's very an American mindset, I would say.
Yeah. And I would like to add that from a constitutional point of view, this is treated as a similar right of admission. I think that the access to a stadium or a concert or wherever, it's a privileged subject, not a fundamental right. Yes. So, in summary, if you have money to go to the World Cup and travel, you also have money to pay your child's necessities. So it's a measure that is between the borders that the civil code and also the constitution prevails.
It is the same here. It's a privilege, not a right. But where the scrutiny will come is because prohibiting people or banning them from stadium might interfere with what we call interstate commerce. And that's where the private company will be the one that's probably fighting the lawsuit, saying, hey, I'm losing business because you're doing X, Y, and Z, you government, and you don't have the right to infringe on my ability to conduct business.
Yeah. Okay, well, thank you very much, Agustín, Paul, for your time and for your great analysis. Thank you very much.
Okay.
Thank you again. Thank you again for having us.
And well, I hope the video has given you some insight, useful insight, and don't forget to subscribe, and we will see you next week with a brand new episode of Droit au but, and that time probably in French. Thank you. Bye.
Bye.
Thank you. Bye.